Question is that the bill be now read a second time. Mr. Pritam Singh.
Mr. Speaker, the death penalty and the collateral criminal justice processes can be highly emotive matters, particularly after an appeal against the death penalty fails. But the varied considerations do not just include the rights of the condemned prisoner. There are other stakeholders in the criminal justice process. These include the rights of victims, the demand for fairness in the judicial system, and the desire that Singapore remains safe for all. For a prisoner awaiting capital punishment, the arguments are not academic discussions of principle, but literally a matter of life and death. Prior to the introduction of this bill, and after the government indicated that it was considering introducing post-appeal procedures for capital cases, I authored an op-ed in our local press on the mandatory death penalty. One point I made was to leave the matter of late applications to the courts and allow cost orders to be the appropriate sanction. My concern was that the legislative changes proposed would either significantly curtail or prohibit post-appeal applications. If this bill was meant to close off the possibility of new evidence being heard or new legal arguments being made in post-appeal applications in capital cases or PACCs, the Workers' Party would vote against this bill. Because of the irreversibility of the death penalty, lawyers should not be unduly fettered from advancing arguments to ensure that justice is done and their clients are saved from the noose. But I note that new material in the form of evidence and legal arguments are not prohibited by the proposals before the House today. The Court of Appeal is to be empowered under the bill to take new evidence. While this bill may appear to some as putting a spanner in the works for lawyers who wish to file PACCs, in my view, it serves to regulate the process better and does not close off defenses not heard at trial. As a matter of principle, I do not see this bill as hampering legal counsel who represent their clients dutifully. The regulation of the PACC process has come into focus arising from the reality of vexatious applications. When I say come into focus, I am not talking only about the sterile procedural aspects of PACCs. The point here is that PACCs cause profound human effects. One cannot discount the reality of these applications taking their toll on the prisoner, their spouses, their children, their parents, their extended families, and their friends. If the hopes created by PACCs are reasonably achievable hopes, natural justice demands that we do not close any door to them. However, in cases of vexatious applications which have a zero chance of success, then the hopes are wickedly false, if the lawyers are aware of that fact. While these prisoners are persons who have been convicted of crimes and who have exhausted their avenues of appeal, we must do right by them, as that reflects what we want to be as a society. If I can sum it up in one word, what most of us want in the system is fairness. Fairness must be a guiding principle in scrutinizing all procedures relating to the death penalty. Of course, some may argue that it is not fair at all for the state to take the life of any person, but that is not the discussion for today. The mandatory death penalty is in our statutes for now. That may change as society or circumstances change, but our purpose today is to look at a sliver of the process and consider the just and fair handling of PACCs. In the interest of achieving a fair process for PACCs, I have a few clarifications about the bill. My first clarification relates to the statement made by the Ministry of Law spokesman and quoted in the Straits Times of 7th of November. The spokesman said, and I quote, "The proposed amendments will clearly set out the process for such applications, and the court will have discretion to allow challenges even if they do not comply with this process," unquote. May I ask the Senior Parliamentary Secretary, what is this discretion referred to here and what is its extent? Is the spokesman merely referring to the provisions in the proposed Section 60J, under which the Court of Appeal may treat an application in another court as a PACC application? If not, could the Minister clarify? Could the SPS clarify? My second clarification concerns the proposed Section 60G7, which provides the matters the Court of Appeal must consider in deciding whether to grant an application for PACC permission. In particular, the matter for consideration in 60G7D is whether the PACC application has a reasonable prospect for success. I would like to confirm if the legislative intent is for para 7D to set a threshold standard, or is 60G7D merely one of 4 factors which must be considered, but which may be overridden by other considerations at the discretion of the Court of Appeal judge. Madam Deputy Speaker, if it is meant to be a threshold standard, it sets a high bar. It could set a high bar that may prevent the applicant from even making a possibly meritorious main application under Section 60H. As such, I would like to clarify if the threshold standard required here is that of an arguable case, and if this would represent the legislative intent insofar as Section 60G7D is concerned. If 60G7D is not meant to be a threshold standard but merely a consideration which could possibly be disregarded if an arguable case comes before the court, I would suggest that this be confirmed in the SPS's roundup speech. My third clarification concerns the phrase "even with reasonable diligence" used in the proposed Section 60G7A, Section 60G15C, and more than once in Section 60M. May I ask the Minister may I ask the SPS what is the intention in using the word "even" in the phrase "even with reasonable diligence"? My reading is that the use of the word "even" suggests that reasonable diligence is being compared with a higher standard, say due diligence. Is that the intention? If so, then to the extent that it endeavors to set a reachable standard, I do not object to it. If the SPS can clarify this, then should the bill be passed, it would make clear to the Court of Appeal the legislative intent is to set a lower standard than that of due diligence. The use of the term reasonable diligence brings me to my fourth clarification. The proposed Section 60G15 provides that where there has been abuse of process, the Court of Appeal, I quote, must not, unquote, grant the application for PACC permission. This is unless evidence or legal arguments are presented that were not adduced before the finding of abuse of process, and evidence or legal arguments could not, even with reasonable diligence, have been adduced in court before the finding. The phrase used is "must not," which can only mean that the Court of Appeal judge has no discretion in the matter. Here, Madam, there is a need to distinguish between the prisoner and the lawyer representing that prisoner. It is possible to conceive of a situation where the lawyer who made the prior application, which was an abuse of process, was not thorough enough in raising evidence or legal arguments that were reasonably available. The prisoner then changes lawyers, and the new, more diligent lawyer then raises the evidence and legal arguments which were available previously but not raised. In such a possible scenario, based on the bill before us, due to Section 60G15D, the Court of Appeal must not grant the application for PACC permission. In such a scenario, it would appear that the Court of Appeal would have no discretion to take into consideration such a situation. May I ask the SPS whether such a scenario was considered when the bill was drafted, and if it was, how does it relate to the proposed Section 60G15D? The remedy against the lawyer who did not raise the arguments could be a personal cost order, but the prisoner should not be unfairly prejudiced. May I ask the Minister why the words "must not" were used? Is it necessary to remove the Court of Appeal's discretion in this case? Mr. Speaker, all my clarifications seek to promote fair outcomes for all parties, which I am sure is also the intention of the government. I look forward to hearing the SPS's responses. Subject to the replies to my queries, I support the bill.